Hello and welcome to Compliance Briefs on Politically Exposed Persons. In this presentation, we will cover several key topics related to politically exposed persons, PEPs. Firstly, the presentation will define what constitutes a politically exposed person and explain what is meant by a prominent public function. It will also look at how family members and close associates of PEPs can fall under similar scrutiny due to their connection to the individual. Next, the presentation will address common misconceptions about PEPs before delving into the duration of politically exposed person status, including how long an individual remains classified as a politically exposed person after leaving office. It will then dive into the risks associated to PEPs, adjusting the level of scrutiny and applying appropriate measures based on the potential risk they pose. The importance of enhanced due diligence will be explained, where more detailed checks and ongoing monitoring are applied to PEPs. Additionally, the presentation will outline key red flags, such as unusual transactions or connections to high-risk jurisdictions. By the end, viewers will have a comprehensive understanding of how PEPs are managed within financial systems. The definition of a politically exposed person is a natural person who is, or who has been, entrusted with prominent public functions in the Republic or in another country. This definition also extends to include the immediate close relatives of such a person, as well as any person known to be a close associate of that individual. When referring to prominent public functions, we are specifically talking about individuals holding high-ranking positions, including heads of state, heads of government, ministers, and deputy or assistant ministers. Members of Parliament or similar legislative bodies. Members of governing bodies of political parties. Members of Supreme Courts, Constitutional Courts, or other high-level judicial bodies whose decisions are not subject to further appeal, except in rare circumstances. Members of Courts of Auditors or boards of central banks. Ambassadors, chargés d'affaires, and high-ranking officers in the armed forces. Members of the administrative, management, or supervisory bodies of state-owned enterprises. Directors, deputy directors, and members of the board or equivalent functions of international organizations. Mayors. These roles are considered high risk due to the significant influence and decision-making power associated with them as well as the resources available to them, which is why individuals in these positions are classified as politically exposed persons, PEPs. Close relatives of a PEP include the following individuals: the spouse or a person considered to be equivalent to a spouse of a PEP. The children of a PEP and their spouses, or persons considered to be equivalent to a spouse. The parents of a PEP. Additionally, persons known to be close associates of a PEP refers to natural persons who are known to have joint beneficial ownership of legal entities or legal arrangements, or maintain any other close business relations with the PEP. Have sole beneficial ownership of a legal entity or arrangement that is known to have been set up for the de facto benefit of the PEP. This broad definition ensures that individuals closely connected to PEPs, whether through family ties or business relationships, are also subject to increased scrutiny due to the potential risk of involvement in corruption or other financial crimes. Following our presentation, we will highlight some common misconceptions about PEPs. Once a PEP, always a PEP. Once a PEP no longer holds a prominent position, a firm should still assess the client's status on a risk-based approach after a period of 12 months to establish whether they still present a higher risk for money laundering or terrorist financing. All PEPs carry the same level of risk. Not all PEPs have the same risk. Although all PEPs are classified as high risk, the risk elements depend on factors such as the position held, jurisdiction, influence, corruption risk, and the nature of transactions. Firms should apply a risk-based approach to identify the exact risk elements and apply mitigating measures to relevant level of risk. Only international PEPs matter. Under national legislation, all types of PEPs, whether foreign or domestic, fall under the same category. Enhanced due diligence measures are the same for all PEPs. Enhanced due diligence measures should be proportionate to the risk elements identified. PEPs are only politicians. The definition of a PEP is broader than politicians and cover individuals holding prominent functions as well as their close family members and associates. Natural persons should continue to be treated as politically exposed persons for at least 12 months after they have ceased to hold a prominent public function. However, enhanced due diligence measures should be applied beyond this 12-month period if, upon assessment, the individual is determined to still present a higher risk for money laundering or terrorist financing. This may be due to the significant influence they may continue to wield even after leaving office. A politically exposed person is classified as a high-risk client pursuant to Article 64(c) of the AML-CFT law. This is because PEPs are generally seen as posing a higher risk for involvement in bribery and corruption due to their position and the significant influence they may hold. If the beneficial owner of a client is a PEP, or if a PEP exercises control over the client should automatically be treated as high risk from a money laundering and terrorist financing perspective. However, a risk assessment should still be performed to identify other areas of risk which the firm should take into consideration when designing the appropriate mitigating measures. It is essential that this heightened risk is explicitly addressed in the organization's risk management policy, and in such cases, enhanced due diligence measures must be applied to mitigate these risks effectively. Firms dealing with PEPs should implement appropriate enhanced due diligence measures and apply risk management systems to identify whether the client or the beneficial owner qualifies as a PEP. Furthermore, they must obtain senior management approval before establishing or continuing any business relationship with a PEP. Firms are also required to take reasonable steps to determine the source of wealth and the source of funds involved. Enhanced ongoing monitoring of the business relationship should also be conducted, alongside regular background checks such as screening. These requirements extend to family members or close associates of the PEP as well. ICPAC has released a guidance on establishing source of funds and source of wealth available on ICPAC's website. Continuing our presentation, we will now cover key red flags that can help detect the misuse of the financial system by politically exposed persons, PEPs. These red flags and indicators for suspicion include instances where PEPs attempt to conceal their identity, such as through the use of corporate vehicles, legal entities, and arrangements designed to obscure the true beneficial owner. Additionally, the use of family members or close associates as the legal owner is another common tactic employed to evade detection and scrutiny. Identifying these behaviors is critical in mitigating financial risks associated with PEPs. In addition, there are several red flags relating to the PEP and their behavior that may raise concerns when dealing with PEPs. One notable sign is when the PEP appears generally uncomfortable or hesitant to provide information about their source of wealth or source of funds. Furthermore, if the information they do provide is inconsistent with other publicly available data such as asset declarations or published official salaries, this discrepancy could be cause for suspicion. Another red flag is the repeated movement of funds to and from countries with which the PEP seems to have no clear connection or ties. Detecting these behaviors is essential for identifying potential misuse of the financial system. Continuing, other red flags relate to the politically exposed person's position or involvement in certain business activities. For example, a significant indicator is when the politically exposed person has control over regulatory approvals, such as awarding licenses or concessions, which could be exploited for personal gain. Additionally, suspicion may arise if the politically exposed person partially owns or controls the financial institution or designated non-financial businesses and professions, either privately or through their official position, particularly if that entity is involved as a counterparty or correspondent in a transaction. These red flags underscore the heightened risks associated with politically exposed persons who hold influential roles in regulatory or financial institutions. Further red flags and indicators relate to the specific industries or sectors in which the politically exposed person is involved. High-risk sectors such as the arms trade and defense industry, where transactions can be opaque and involve sensitive dealings, are of particular concern. Additionally, politically exposed persons engaged in the construction and large infrastructure sectors may be exposed to heightened risks of corruption or misappropriation of funds. Another sector to watch closely is the provision of public goods and utilities, where politically exposed persons may exploit their position to influence contracts or divert resources. These industries often involve significant government oversight, making them prone to potential misuse by politically exposed individuals. Another important category of red flags concerns the nature of the business relationship or transaction. Key indicators include the deposit or withdrawal of large amounts of cash from an account, as well as the use of bank checks or other bearer instruments to make substantial payments, which can signal attempts to obscure the origin of funds. The use of large amounts of cash within the business relationship is another red flag, as it often indicates a lack of transparency. Additionally, when personal and business-related money flows are difficult to distinguish from one another, it raises suspicions about the legitimacy of the financial transactions and the true purpose of the business relationship. Red flags related to the products, services, transactions, or delivery channels also warrant attention. One such indicator is when payments are received from unknown or unassociated third parties, which can obscure the true source of the funds and raise concerns about the legitimacy of the transaction. Another critical red flag is the use of anonymous transactions, particularly those involving cash, as these can facilitate money laundering and make it difficult to trace the origin or destination of funds. Country-specific red flags and indicators are also crucial in identifying potential risks. A significant warning sign is when the politically exposed person originates from a country that credible sources, such as international organizations, have identified as having a high risk of corruption. Similarly, politically exposed persons from countries known for high levels of organized crime also pose an elevated risk. These factors can significantly increase the likelihood of illicit activities such as money laundering or misuse of financial services, and should prompt heightened scrutiny in business dealings with politically exposed persons from such regions. We hope you found this useful. For any queries, you may contact us at compliance@icpac.org.cy. Thank you and goodbye.